We've got an indictment here, 25 CR 1791, that accuses Michael Wayne Osborne, that's you,
Yes,
correct, of the state jail felony of burglary of a building. And it also alleges that you have a forgery conviction out of this court in 97. And then paragraph 3 goes on to allege that after that 97 conviction of forgery was final, you committed the offense of unlawful possession of a firearm by a felon and were convicted of that in Orange County, Texas. So this state jail felony then becomes.
Right out of the gate, the judge is laying down the stakes like a poker dealer showing all the cards. What started as a state jail felony just got supercharged because of prior convictions, in plain English. Those past cases are turning this burglary charge from bad to potentially life-altering, and notice the judge immediately trying to control the courtroom tempo. That becomes a huge theme in this hearing.
Punished as though it was a third or second, because they're in sequence. If you don't interrupt me, okay? That's rude. And we can't all speak at one time. Hold on, you're going to get a chance to speak. So this appears to be indicted as a state jail felony, though it's punished as a second-degree felony if found guilty. So you are looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing in this charge? Now you can speak.
I do not.
Okay, good.
Yeah, well, I guess I started off.
There are several things that you filed here. Let's see. You got a motion to dismiss counsel that you filed. What was the date on this? I don't see it's undated. And that Miss Minaldi has been appointed to represent you. Are you able to hire your own lawyer?
No, I filed a motion to proceed pro se and to be admonished. I also filed a motion for recusal.
I know. I just asked you a question, sir. Just, are you able to hire your own lawyer, though? I'm
proceeding pro se.
This is yes or no. This isn't a hard one to figure out, sir. Are you able to hire your own lawyer if you wanted to, though?
No.
Okay, you're because you're in jail and you don't have an income. All right, you're indigent then.
Yes.
You can already feel the friction building here. The defendant keeps trying to jump ahead to his motions, but the judge is laser focused on one thing first. Can this man legally represent himself? And trust me, judges get very cautious when someone says they want to go pro se, because once a defendant waives counsel, the court has to make sure they fully understand they're walking into a legal battlefield without armor.
Right, okay. All right, we're going to take these one at a time. Motion to dismiss counsel here. Why do you want that? Because this lady is here to represent you. You believe you could represent yourself better? Is that what you think?
Well, I'm sure you're aware, Judge, that I've been through this before and I represented myself. I have no problem with it. It's a barrier of communication when she offset this case and didn't network with me. Then I didn't want this presiding court even to adhere to the alleged offense. I don't want to be tried before this court, not with you presiding.
Why is that?
Well, if you don't recall, you should remember 8-9 years ago, you refused my agreement, and then you still sentenced me, and you never gave me my back time. And I don't see how we can entertain this today when I filed a motion to recuse and you still entertaining the kid.
Yeah. Well, first of all, back time. I don't have number one. You're so wrong because back time is not in this court's discretion. It's law. If you have time credited, you have to be awarded to this. And the court has never in 20 years denied back time that is allowed by law. So that doesn't make any sense there on that one. Number two, you can certainly represent yourself at any time if you wish, so long as you are completely aware and appreciate that the people who represent themselves pro se generally are not successful because attorneys are more profoundly aware of the rules of evidence, the penal code, the code of criminal procedure, and other laws that are used in the trials. Representing yourself is always a disadvantage. That's why it's a long statement. People who represent themselves have foolish people for their own clients. That was something that was part of the history of law before I was born, because there's not a lot of success at doing that. And when you're not adept at the rules of law, then you can.
This is one of those classic courtroom moments attorneys love quoting. A person who represents himself has a fool for a client. The judge is basically giving the legal version of a flashing warning sign. Evidence, rules, procedure, objections, jury instructions. This stuff is a maze even lawyers spend years learning. And yet, despite all that, defendants absolutely do have a constitutional right to represent themselves, even if it's a terrible strategy.
You have a disadvantage, but you're an adult. You get to make your own choice. If you want to represent yourself, you just have to know that when you represent yourself, you're going to have to follow the rules of law and the evidence and the court of criminal procedure and the rules of criminal procedure and the penal code and any other rules that may come into the trial process. Let's see. And you'll be able to represent yourself if that's what you clearly want. Have you ever represented yourself in any criminal proceedings before?
Well, I'm sure you are quite aware that I have.
No, that's just yes or no. And just play like I haven't had 50,000 defendants in this court.
Wow.
You're going to have to refresh my memory. Go ahead. What have you done? What's your experience in representing yourself?
I started out with, Your Honor, with the fact that I filed motions that the court is not adhering to, and it seems to me that you're depriving me of due process because I don't want this court to preside, you to preside over this case.
Well, when you have good cause, just because you don't want,
Okay.
if you want to interrupt me all day, we can't both speak, because when you speak over me, this lady can't take what you're taking down, what you're stating. And it's rude, number one, but it's impossible for her to take what you state. Let me speak, then you'll get an opportunity to speak. Okay. All right. Look, the Constitution of the United States does not state you anywhere that you get the choice to make your to have a judge of your.
And there it is, the power struggle becomes crystal clear. The defendant wants the judge removed, but legally, disliking a judge isn't enough. You need actual evidence of bias or a conflict serious enough to justify recusal. The judge is basically saying you don't get to custom order your judge like a fast food combo. Harsh delivery. Maybe, but legally, he's on solid ground here.
Wish before you. And that's, you get a judge who is a lawfully presided judge, and that's what you get. Just because you don't like me to preside over your case, that's not enough to grant your wish. Then I have a motion to quash an indictment here that you have filed, and Can you summarize the reason that you filed this?
That was predicated, Your Honor, because it fails to state, I don't have a document, probable cause, information, or anything to go by. And first of all, I never entered any building,
No,
broke into any building.
but that's not, that's what we deal with at trial, but the four corners of the indictment,
All
what's
four
wrong?
corners, it doesn't meet the element of burglary of a building.
What does it fail to state? Because
fails to
it states,
giving notice that I fully entered, partially entered, something to that effect, in which that would probably give me the benefit of defending myself against.
okay, in summary, this states the elements of the penal code of burglary of a building clearly in this paragraph that on or about October 15th, 2025 in Jefferson County, Texas, with the intent to commit theft, you intentionally and knowingly entered a building or portion of a building not then open to the public without the effective consent of the owner. Those are the elements of burglary of a building. Anything else? What was it missing? What was the element that's missing that's in the penal code that you're saying?
Into the building.
Oh, but it's an allegation, sir. It's not, that's what we do at trial, it alleges, it's what the allegation is. That's why we have a trial, and that's why you get to present evidence, the state presents evidence, and a jury makes a decision. Everybody who pleads not guilty contests what it says. The question is the four corners of the indictment. Does it allege the allegations that are required for the commission of a crime? And it does. That's why we're going to go to trial.
This exchange is a perfect example of the difference between arguing facts and arguing legal sufficiency. The defendant keeps insisting he didn't commit the burglary, but the judge keeps redirecting him back to the indictment itself. At this stage, the court isn't deciding guilt or innocence, it's deciding whether the charging document contains all the legally required elements of the offense, too completely. Different battles, and the defendant keeps trying to fight the wrong one.
So that's denied.
Yeah.
The motion to quash is denied. It does
I'd like a copy of that.
properly fit the elements of the indictment, and you filed it more than once here. There's a motion to quash on December 19th. What's the difference?
I never got an answer. This is why I refiled it.
That's why we're here today. The motion is denied.
This
Let's
is
see.
nothing but
Wanting to advance pro se. What, you're just so rude. Interrupt the court. I told you have a chance to be heard, sir. You can't help yourself. How many times we learned that in second grade. Not that our teachers would scold us. Don't be rude to others and don't speak over others. You're going to get a chance to speak.
Notice how the judge almost sounds frustrated but still keeps the door open for counsel. That's intentional. Courts hate appeals based on "I didn't understand what I was doing." So the judge is creating a very detailed record showing, "I warned him repeatedly. I offered counsel repeatedly. He chose this." That transcript could become incredibly important later if there's a conviction and appeal.
Okay, wanting to advance pro se, that's granted. You're going to get that. That's all. Now that's all I have here. The motion to quash, hold on. The motion to quash is denied. The motion to proceed pro se is granted. That's another pro se. That's granted. Motion to dismiss counsel. That's granted. Anytime you want to change your mind on that, though, I would urge you, let me know so a competent attorney can be appointed to represent you. Does he file something? I'm sure he's not able to pay, and Mr. Osborne is deemed a transient. Is there something in there that shows he's indigent, though, so that we can appoint somebody? There is an affidavit of indigence that was never signed by you. That needs to be filled out.
Yes, sir.
So that if you, and it looks like the magistrate, it looks like Judge DeRuin
Yes, sir.
went over it, but you wouldn't sign it or fill it out.
No, I filed to proceed pro se, and I filed for an examining trial. I requested one immediately.
Okay, but here's the deal. Anytime you want to change your mind, which is the right you have under the Constitution, to have a lawyer represent you, what would happen is we'd have to stop everything we're doing and get you to fill out an indigent form. If you fill out an indigent form now, it's in there ready to go in the event you change your mind.
Okay.
But it's your call. If you don't want to do that, but it stalls everything, you know. I would urge you to do it just to have it as a safety. Okay, sir?
But one thing, did you get the motion for an investigator? I sent that as well.
I'm looking at all of this and okay, motion to dismiss. There's no investigator in that. It says wanting to advance pro se. I'm treating that as a motion for pro se, and I don't have it. That's it.
Okay.
That's all I've got here. And then here is there's something about this says motion to recusal, and then it refers to Judge DeRuin, though. Establish the wanting for examining trial. Is that right?
Yes, sir.
Okay. You don't get an examining trial if you have been indicted. If the grand jury indicts, which they've indicted in November, an examining trial is no longer an option. Says you are illegally confined in the jail. Information indictment, that's paramount. Said John seems to stop. What is that? Step aside, I think is which is some paramount importance. The leading force of this matter is predicated on facts and a profound complaint. Further complaints presented before Mr. Sims made Stephen's failure to not accept the plea agreement in the state felony in the past. From what has happened. First, what may happen. Articulates the presiding judge. The decision years back in a state jail case. I guess it was in this forgery case. Is that right?
He was, yeah,
Okay. Which I really can't read your.
I know.
Where premise is considered prevalent, that said judge step aside in the best interest of justice. And I don't understand your writing because it's hard to write in there. But I don't understand what you are articulating that would cause this court to step aside. It seems to state you just don't prefer me, and that's not enough, under law. But if you want to write some more, go ahead. But at this time, I don't find that the four corners of your pro se motion sets forth valid reasons for this court to step aside.
And just like that, the hearing closes with the judge firmly in control and the defendant officially moving forward alone. No new judge, no dismissal, no quashed indictment. What started as a procedural hearing slowly turned into a live demonstration of how difficult self-representation can become when emotion collides with courtroom. Procedure. The real question now is, will representing himself help him feel empowered, or walk him straight into legal quicksand?
Okay. So we're going to continue to move forward and you want to continue to represent yourself.
Yes, sir.
All
I would
right.
like
And you want to go to trial.
right. I would like copies of all that's been denied as well. And a copy of my indictment, copy of the cause, and information if at all possible, Judge.
Yeah, okay. If, Reagan, can you make just a comment as possible at any time you want to change your mind?
Alright.
Let me know immediately so we can get somebody in here, okay? Yes, sir.
Sure.
All right, sir.
Thank you.
All right, thank you.